So how do you take an adjournment? You pray the court for an adjournment and give the purpose of the adjournment. So you could say that, my Lord, we will be humbly praying the court for an adjournment to enable us bring our witnesses to court. That's if you were supposed to, take witnesses, examination, and then you did not produce your own witness. Or if you wanted to put your house in order, maybe, you mixed up some files, or you did not file a motion you were supposed to file, or you've not paid, some fees that you were supposed to pay for probably filing out of time or anything, or you just want to regularize your position before the court, you could ask for an adjournment in order to put your house in order. So you could say, we'll be praying this honorable court for an adjournment to enable us put our house in order. Hi guys, welcome to my channel once again. This is Bat Up with Ola and my name is Mojola Olua. Today we want to talk about adjournments. If you haven't subscribed to my channel, please subscribe, like this video and as many videos as possible on the channel, and leave me comments in the comment section. By the time we reach the 50th episode, I would like to do a question and answer session. So I'd like you to start dropping me your questions, and you can send them to my email. The email is in the description box. Please send me your questions, your legal questions, your legal dilemmas, and we will answer them all in the 50th episode. Today let's talk about adjournments. An adjournment is a temporary pause or postponement of proceedings in court until another day. It could be at the instance of the court itself, or at the instance of the parties involved in the matter, or at the instance of the lawyers involved in the matter. And of course, there could be a supervening event which could cause an adjournment. For instance, a public holiday, an act of God, and so many other things. But essentially, an adjournment signifies a pause, not the end of the case, but a pause in the case until another day. An adjournment could be definite or indefinite, that's sine die, but in most cases it is definite because proceedings have to continue and be concluded in cases before the court. A very important thing to note is that an adjournment has to be reasonable. Because there's an opportunity for an adjournment, it doesn't give lawyers or the courts or any of the parties a leeway to exploit this opportunity. Most times, when it's not an act of God or a supervening event, it is at the court's discretion. When it's at the instance of the court, it could be that maybe the judge had to go somewhere, had another official assignment, or fell sick or was ill, or could not make the proceedings as due. When it's at the instance of the lawyer, it could be that the other party did not show up, or it could be that both parties need the adjournment to put their house in order, maybe to get a document or to get a witness in court, or to get the parties to come to court themselves, or to do one thing or the other, to file a motion, to regularize their position before the court, or do one thing or the other. So it could be at the instance of the lawyers too. And when it's at the instance of the parties, that's most times in criminal matters. If the defendant is absent in most cases and at certain stages of the trial, the case cannot proceed. So the court has to pause, take an adjournment for the defendant to be produced. Sometimes it could be that, the correctional facilities did not get notice to bring the defendant to court, or the defendant could have jumped bail if he's on bail. Anything could have happened. But if he's not in court, especially before arraignment, adjournment has to be taken for him to be brought to court to face the charges against him, especially to take his plea. Plea cannot be taken behind an accused person. I've done a very extensive video, short but extensive, on arraignments. I'll put a link to it in the description box. You can watch it and leave me comments on that video as well. And please make sure you like the video. An adjournment is not to be mistaken for a stand down. A stand down is different, and that's because a stand down is a temporary pause in the proceedings for the day. That is, the proceedings will still go on that very day. But if it's an adjournment, the proceedings have been stalled and paused until another day. That's the essential difference, the time difference. A stand down is when you ask the court to, pause your matter until probably the other lawyer comes, or maybe you get a document, or you put yourself, your position in order before the court. So you ask the court to please stall the matter. Maybe it's been called and the proceedings were going on, and maybe you needed to quickly dash out and file something at the registry, or maybe get out and call a witness that you were expecting but that's not around, or do one thing or the other. You can ask for a stand down. That means the case will still be called that day and it will continue. But when it comes to adjournments, once the court adjourns, it adjourns until another day. That's the essential difference between an adjournment and a stand down. It's important to note that the court is not a court of adjournment. Most judges will tell you that. And that usually comes up when perhaps a party or a lawyer has been asking for adjournment upon adjournment in a particular matter. It's not healthy, it's not good, because justice delayed is actually justice denied. I know that they say that the will of justice, though slow, is certain, but taking adjournments upon adjournments is one of those factors that slow down the will of justice, especially in Nigeria. So it's important for you as a lawyer not to be an adjournment lawyer, and as a court not to be a court of adjournment. Most judges frown at adjournments when it becomes excessive. It's not the best. It doesn't work in the interest of both parties. Parties get weary. Witnesses get frustrated and tired. And of course, it does no good when something that can be done in 6 months, 3 months, gets to be done in like 3 years, 6 years. It's not the best. And that's why most people, stay away from legal recourse in this part of the world. Most people would not go to court because they believe that our courts are courts of adjournments, and then they have to stay in court for years for a matter that can be settled faster. So adjournments are like a blessing and a curse. A blessing because it could be a very favorable pause in the case that's going on, so that a lawyer can put his house in order, so that the court can take a break from a very long trial day, so that witnesses can be refreshed after a prolonged proceeding, so that people can get documents, and a lot of things can be done. But when it now begins to stall the proceedings such that people are getting weary and not much progress is being made, then it becomes a curse. So it's a blessing and a curse. And it's important as a lawyer not to be an adjournment lawyer, because the court takes notes. So usually they factor these things into their judgment. Sometimes judges become reluctant to give adjournments if a lawyer has become notorious for taking adjournments. So it's not the very best. It's better to prepare ahead and do your matter, because most lawyers hide under adjournments to not do what they're supposed to do. So it's important for lawyers to do their part so that they do not become adjournment lawyers, and it's important for a court not to be a court of adjournments. Sometimes adjournments are also at the court's instance. In any case, there are times where adjournments are inevitable. When the court has had a long day, by all means the court has to put an end to proceedings for the day. Proceedings cannot endure into the night or whatsoever. So the court will at some point have to adjourn if a case cannot be concluded in a day. And that's the most important rationale behind the provision of adjournments in law courts, because cases cannot be prolonged into the night, into the next day, and all of that. The court has to close for the day, for each day, before resuming at another time, at another date. That's the most important rationale behind taking and giving of adjournments, aside the fact that it could come to the rescue of the court or come to the rescue of the parties or of the lawyers at one point in time or the other. So how do you take an adjournment? If it's at the court's instance, the court might ask you to take a date. Usually the judge will say that, oh, Mr. So-so-so, Miss so-so-so-so, that's the lawyers, please take a date. So you adjourn to another day for a certain purpose, because the court has to note it in its record that this matter was adjourned, or this matter is adjourned to so-so-so date for so-so-so-so. So when the court is pronouncing the adjournment, it would usually say that this case is adjourned to 15th of June 2022 for report of settlement, or this case is adjourned to 22nd of October 2021 for hearing, or this case is adjourned to 10th of November 2021 for mention. The court has to adjourn to a certain date and to a certain purpose. So that's it. When it's at the court instance, the court will ask lawyers to take a date, and usually the registrars come into play because they are the ones with the court's diary. So it's important to sometimes be friendly with the registrar so that they can give you a short date. But there are times when you wouldn't even get a short date, no matter how friendly you are. That's when the court's diary is already full. So they would most likely give you the next available date, which might be far or farther than you want or expect. Now, if it's at the lawyer's instance, the lawyer has to pray the court for an adjournment. For instance, let's say the other party in the matter has not shown up. The lawyer can stand up and say that, oh, my lord, Mr. So is in this matter with us. He was here at the last adjourned date. We have not seen him today. We do not know why he's not here, but in the circumstances, we'll be praying the court for an adjournment. That's if probably the lawyer is not around and he has not communicated his absence. If he has communicated his absence, because there's a provision. Actually, the due process is that if you're not coming to court as a lawyer, you should write the court. Give the court your reason, your tangible reasons, and you could suggest adjournment dates. And now, because of modern technology, phone calls are very easy to make. So you could call the other party, tell them why you'll not be coming, and you could agree on suggested adjournment dates that the other party will present to the court even after you've written your letter. So usually when the other party gets to court and is telling the court that, oh, we've spoken and he suggested these dates, the court will also confirm that, oh, this letter was received from him and he suggested this date. So if the court is being magnanimous, they would ask you to choose any of the dates suggested, and then the court would adjourn to that date. But if those dates are not free, which is very possible, the court might impose its own date on you or ask you who is present to suggest another favorable date that would agree with the court. The essential point is that the date a matter would be adjourned to must be favorable to the court and to the lawyers involved. So usually that's why the court would always say agree on a date. That is, counsel in the matter agree on a date, counsel opposing counsel agree on a date. So you have to agree on a date that's favorable to both of you and convenient to the court. So usually when you pray the court for an adjournment, you could also say that subject to the overriding convenience of this court, we'll be praying the court for an adjournment. We'll be asking to come back on the so date of so month, so year for report of settlement. Subject to the overriding convenience of your lordship, we'll be praying the court for a date in June or a date in July. That's if you're not certain of a definite date. Then the registrar will check for you a free date, and then he will suggest it to the court. If the court agrees, the court will grant you the adjournment. If the date is not free, for instance, so the court does not agree, they would ask you to choose another date. So you could say, subject to the overriding convenience of your lordship, we'll be asking to come back. We'll be praying the court for a date in July, for us to come back for report of settlement. Then the court would likely say something like, registrar, give them a date in July. I'm sounding like one of the judges I used to appear in front of. So the court would most likely ask the registrar to give you a date in July. That's if you've not provided a definite date. Or if, for instance, you want to put your house in order, you could say that, my lord, bring this honorable court for an adjournment for us to put our house in order. And the court will ask and say, okay, take a date. And then you say 15th of July, for instance. The registrar will check it for you. If it's convenient, you'll say, it's convenient, my lord. And the court will now say, this matter is adjourned to 15th of July to enable counsel put his house in order. So it's very simple. You pray the court as usual. We pray the court for everything we do in court. You pray the court grants it, and then it records it for you, and then you have your adjournment. So the court could ask you to take a date, or you could pray the court for a date. That's the way adjournment works. So what have I said in this video? Adjournments are an integral part of our legal system. It enables the court, to pause a matter, a proceeding before it for the day until another date. It is not compulsory for lawyers or the court to give or take adjournments. Adjournments are subject to the discretion of the court, subject to the overriding convenience of the court. The court could impose a date, or they could give you a date that you want or that's favorable to you, subject to the court's diary. And it is important to not become an adjournment lawyer. And it's important for a court not to be a court of adjournments, so that matters can proceed and, resolutions can be reached and justice can be served to one and all. So like I said at the beginning of the video, when we reach the 50th episode, I'd like to do a question and answer session. So if you have any legal questions, any questions of law that you'd like to ask me, please shoot them to me in my email or leave them in the comment section. I will be answering them all in the 50th episode. I will always see you in my very next video. Don't forget to subscribe to those.